Let's take a look at drug tests from an employment law perspective. Many employers require employees to undergo drug testing in a variety of circumstances. Tests are given prior to hiring for verification as directed by a substance abuse professional under reasonable suspicion of drug use, after on the job accidents, and at random times. In random drug testing, a specified percentage of the workforce is selected for periodic drug testing without prior notice and without individualized suspicion of drug use. If proper procedures are used, a drug test can determine with reasonable certainty whether specified illegal substances are in a person's system. The legal rights of employees vary considerably according to whether they work for the government, are unionized, or live in a state that has chosen to regulate drug testing. Approximately half of all states have laws that deal with drug testing. Some of these laws require drug testing of certain types of employees or under certain circumstances, and no state prohibits all drug testing of employees. Laws in approximately 10 states prohibit random testing outright or limit it to occupants of safety-sensitive jobs. Employers should be especially careful in deciding whether to use random drug testing. When employees are represented by a labor union, employers are generally required under the National Labor Relations Act to negotiate with the union about whether there will be drug testing and what any program should entail. Public employees challenging drug testing programs of public employers have argued that it's unconstitutional because it violates the Fourth Amendment, which protects against unreasonable search and seizure. The Supreme Court has consistently held that drug testing, in which employees are required to submit fluids and have them analyzed for the presence of illegal substances, constitutes a search. Drug testing predicated by an employer's observations of behaviors is certainly reasonable and constitutional. The Supreme Court has also upheld testing of U.S. Customs employees who carry firearms or who handle illegal contraband, including narcotics, as a requirement for promotion. Testing on a random basis is arguably the most intrusive form of drug testing, and it's not based on any particular suspicion of drug use or predicated by any action on the part of the employee. The U.S. Supreme Court has not squarely addressed the issue of random testing in a workplace setting, although it's upheld random drug testing of high school athletes and students participating in after-school programs. The surest way to defend drug testing programs is to focus on safety-sensitive jobs and emphasize testing based on reasonable suspicion. To establish reasonable suspicion, supervisors must be well trained at identifying signs of impairment. Some employers are not just permitted, but legally required to test employees for drug use. The most general statutory requirement for drug testing is found in the Omnibus Transportation Employee Testing Act. This federal law requires drug testing of employees in transportation-related occupations, including airline, railroad, trucking, and public transport workers. Legal questions surround not only whether drug testing can be done, but also the manner in which it's performed. One source of legal requirements for drug testing procedures is state drug testing laws. Some of the more common procedural requirements found in these state laws are the following. Employers must provide written notice that testing is required. They must provide copies of the substance abuse and drug testing policy and must use licensed laboratories. Employers must perform confirmatory tests, and employees must be given test results in writing, as well as those employees who test positive must be given the opportunity to explain, and samples must be collected privately. The Department of Transportation's regulation for drug testing under the Omnibus Transportation Employee Testing Act set out procedures, including steps to balance privacy in producing the sample with safeguards against adulteration. The Act does not provide individual employees with the right to sue for improper drug testing procedures. It also appears to supersede state laws that would otherwise allow employees to sue over improperly conducted drug tests. Although it does not appear that courts will seriously entertain negligence suits against employers for faulty testing, claims against laboratories conducting drug tests might be another matter. State laws requiring that employers provide employees with copies of their substance abuse policies dovetail with the Federal Drug-Free Workplace Act. This law applies to companies that have contracts to provide goods or services to the federal government. The Drug Free Workplace Act is silent on the subject of drug testing. Instead, it requires that covered employers develop and communicate policies prohibiting drug use in the workplace, establish penalties for violation, and report the funding agency any convictions related to drug use in the workplace. Employers should have policies notifying employees if they're subject to drug testing, the circumstances under which testing will occur, and the consequences if testing is positive. Courts are reluctant to protect at-will employees from termination based on drug tests, even if the tests were conducted improperly. Disparate treatment claims are possible if the drug test results of otherwise similarly situated employees led to one employee being terminated and the other being given more lenient treatment based on protected class characteristics. Employers that discharge unionized employees for positive drug tests sometimes find their decisions are overturned by arbitrators because the testing was not done in conformance with contractual requirements. Even with public policy strongly favoring elimination of illegal drug use, courts have generally upheld the decisions of arbitrators to reinstate unionized employees testing positive. Drug test results are sensitive information, and employers should treat the results as confidential. Divulging such information to parties that do not have a legitimate need to know can violate the privacy rights of applicants or employees and violate confidentiality requirements of state drug testing law. A positive drug test cannot support statements such as the tested employee is a drug addict or came to work high on drugs. Instead, the test simply indicates the presence of an illegal substance, nothing more. The need to ensure that drug testing results are described accurately and handled confidentially is another reason for using a medical review officer to oversee a company's drug testing program. Many employers provide employee assistance programs, known as EAPs, to help employees with substance abuse problems and give them second chances. Only after an employee who is addicted to illegal drugs has been allowed to undergo treatment in a rehabilitation program or has successfully completed such a program is that employee protected by the ADA. Employers must not decide to terminate, fail to promote, or otherwise discriminate against an employee who's undergone treatment for drug addiction and is no longer using illegal drugs. A one-strike rule, under which employees who test positive for illegal drugs are never again considered for employment, is lawful. A medical examination is defined as any procedure or test that seeks information about an individual's impairments or health. Figuring out whether a medical or health-related procedure is in fact a medical exam subject to the ADA's rules is not always a simple matter. Here are the factors that are considered in making such a determination. The test is administered by a healthcare professional, designed to reveal physical or mental conditions, it's invasive, it's performed in a medical setting, and requires the use of medical equipment. All of these factors need to be present. The ADA governs whether medical exams can be conducted, which types of exams can be performed, and what uses of information from medical exams can be put. The ADA's requirements differ depending on the stage in the employment process. Prior to making a conditional offer of employment, employers are prohibited from requesting or requiring that applicants submit to medical exams. Even so, this does not mean that employers must make hiring decisions in the absence of information about the health of job candidates. After the employer has extended a conditional offer of employment, the employer is free to require a medical exam to verify that the person is physically and mentally capable of performing the job. Medical exams, if used, should be the last test performed and considered prior to finalizing hiring decisions. Individuals cannot be required to take medical exams unless they're given to all other persons hired in the same job category. The ADA does not limit the scope of medical exams following conditional offers of employment. In contrast, medical exams of current employees are limited to those that are voluntary, job-related, and consistent with business necessity. Because employers have ongoing evidence about job performance of their current employees, that information and not medical exam results should be the primary basis for employment decisions. Medical exams are job-related and consistent with business necessity when employers have reason to believe that individuals may be unable to perform their jobs because of their medical conditions or that they may pose a direct threat to safety. A medical exam can also be required to document the existence of a disability that necessitates accommodations. Finally, the law allows for medical exams of current employees when these are truly voluntary, such as if the employee chooses to use an employer-sponsored blood pressure screening or other wellness program. The results of the exam cannot be used to deny an employment opportunity to a disabled person unless that person is unable to perform the essential functions of the job, even with a reasonable accommodation. However, if a medical exam uncovers information about a condition that does not meet the legal definition of a disability, the ADA does not preclude use of that information to deny an employment opportunity. Employers are nonetheless skating on thin ice when they exclude individuals who are not currently disabled because of a belief that they might develop a disabling condition later. Medical exams also include genetic tests aimed at assessing the predisposition of persons to develop a medical condition or pass them to offspring. Knowledge regarding the genetic makeup of humans and the basis of diseases has been rapidly accumulating. Genetic testing promises medical benefits, but also lends itself to misuse, particularly in the hands of employers and insurers. The Genetic Information Non-Discrimination Act, known as GINA, covers employers with 15 or more employees and applies to both employment decisions and to health insurance. Concerning employment, employers must generally refrain from requesting, requiring, purchasing, or otherwise acquiring genetic information regarding applicants and employees. Genetic information includes information from genetic tests of an employee or a family member, family medical history, requests for genetic services by an employee or family member, and genetic information about a fetus. Information about which medical conditions run in a family is considered genetic information. In contrast, information about conditions or traits already manifested by employees does not fall within protections of GINA. There are some narrow exceptions to the prohibition of acquiring genetic information, such as isolated cases of inadvertent disclosure of genetic information by employees. One of the circumstances under which employers are especially likely to violate GINA is when they make requests for medical information to healthcare providers. The EEOC has suggested language for making such requests that, if used, provides employers with a safe harbor. Employers should use the suggested language when making requests for medical information from healthcare providers. The language references GINA, explains the meaning of genetic information, and then states to comply with this law, we are asking you not to provide any genetic information when responding to this request for medical information. To the limited extent that employers can lawfully possess genetic information, this information is subject to the same confidentiality requirements that the ADA imposes on medical information of all types. Confidential handling and maintaining the information in files separate from the employee's personnel file is required. Genetic information is medical information, and genetic tests are a specific type of medical exam. The ADA's limitation on a medical exam and inquiries and on the use of medical information apply to genetic information. GINA, however, goes further in limiting the acquisition and use of this particular type of medical information. Although the scope of medical exams administered following a conditional offer of employment is not restricted by the ADA, GINA requires that such exams must not include any genetic information gathering. Employers must never use genetic information for making decisions about employment opportunity. Not surprisingly, employers would like to know whether candidates' representations are credible and whether they can be trusted if hired. A number of tests purport to be able to do so, including polygraphs and voice stress analyzers. A polygraph does not detect lies, but rather measures changes in physiological responses, including respiration, blood pressure, and perspiration. Voice stress analyzers focus on changes in vocal patterns. Telling lies is thought to be stressful. prompting physiological responses or vocal patterns different from baseline readings established by answering simple questions. Polygraphers administer exams and combined their own observations of tested individuals, the physiological indicators, attempts to elicit admissions from persons tested, and a little intuition to determine whether there is deception. Individuals can thus be rejected either because it was concluded that they're engaging in significant deception or because they confess to something serious during polygraph exams. Concerns have been raised about the accuracy of these tests, intimidation tactics used by polygraphers, and invasive questions. Prior to passage of the Employee Polygraph Protection Act, pre-employment polygraphs were widely used. The law is now clear. Private sector employers must not request or require that applicants submit to polygraphs or other mechanical or electrical truth-determining devices. There is a limited exception for private sector employers producing or dispensing controlled substances, narcotics, or providing heavy security services like guarding nuclear power plants or water supplies. Importantly, government agencies, including law enforcement and security agencies, are still free to polygraph both applicants and employees. Although the EPPA negates the use of polygraphs in hiring, the law allows polygraphs to be used by private sector employers in conjunction with investigations of employee theft or other serious wrongdoing. To fill the void left by the polygraph, many employers have turned to a paper and pencil honesty test, also known as integrity tests. These tests are not regulated by the EPPA. Employers use a variety of tests to assess desired characteristics such as intelligence, job skills or knowledge, work-related attitudes, personality traits, and physical fitness. These tests are typically scored in some fashion, and persons who score better, or at least above a specified cutoff point, get hired. The main concern is that the tests not be discriminatory. Frequently, scored tests of ability are developed by consultants or testing companies that sell the rights to use the tests to employers, score the tests, and interpret results. However, the involvement of a third party does not absolve employers from responsibility for the tests and from taking responsible steps to ensure their legitimacy. Employers need to pay attention to question wording, the effects on protected groups, proof that tests are job-related, the scoring methods, and accommodation of disabled test takers. Many employment tests are given on paper or online and contain numerous questions for candidates to answer. These items should be examined to see whether they relate to protected class characteristics, and tests containing such items should not be used. In an instructive case, the parent company of Target stores used a psychological test devised by a testing company to screen applicants for store security guard jobs. These questions not only constituted pre-employment inquiries about protected classes. In California, where the case arose, sexual orientation, as an example, is a protected class, but also were scored by the testing company. Thus, some answers to these questions were deemed more desirable than others, and the manner in which an applicant responded affected the ability to be hired. On a variety of grounds, including discrimination based on religion and sexual orientation, the court granted the plaintiffs a court order to stop the testing. The employer eventually settled with the class of plaintiffs for more than $2 million. It does not take a great deal of technical sophistication to examine test questions and to red flag those that pertain to a protected class or are otherwise inappropriate. The latter category includes questions that presume the sex of the test taker or that are premised on religious or cultural beliefs that would be more familiar to some protected class groups than others. Tests that contain such items simply should not be used. An overriding legal concern with scored tests in employment is that they can produce disparate impact discrimination. Although the tests are neutral requirements, assuming that the same tests are given to all candidates for the same jobs and are scored in the same manner, they may nonetheless have discriminatory effect. To watch for discriminatory effects, applicant flow data compares the protected class composition of an applicant pool to that group of people who pass the test and are eligible for an employment opportunity. The underlying premise is that although individuals vary widely in their abilities, overall, people of different races, sexes, national origins, and other protected classes are equally capable of doing most jobs. Thus, we would expect that men and women, or whites and blacks, should have similar rates of success in passing the tests and obtaining employment opportunity. If instead, men pass the test at a much higher rate than women, or whites pass the test more often than blacks, such an outcome indicates that some aspect of the test is producing discriminatory effects. How different must test outcomes be to conclude that discriminatory effects or disproportionate selection are occurring? One simple guideline is the EEOC's 4/5 rule. The rule says that if the selection rate of one race or sex or other protected class group is less than 80% of the group that was most successful at passing the test, that result constitutes evidence of discriminatory effect. The 4/5 rule is a useful rule of thumb and is given some deference by the courts, but it does not always suffice. It can be misleading when the number of applicants is small. In one case, pass rates for whites and African Americans on a promotional test for firefighters violated the 4/5 rule. But because the number of candidates taking the exam each year was so small, there was not a prima facie case. In another case, selection rates on an exam satisfied the 4/5 rule, but other statistical methods showed that the difference in the mean test scores between white and African Americans was still far larger than would be expected by chance. The plaintiffs were thus able to establish a prima facie case. When cases go to the court, expert witnesses are typically called to present more sophisticated statistical analysis. The techniques used vary, depending on the groups compared and the sample size, but they share the aim of showing that any differences in selection rates or scores for protected class groups are statistically significant. This means that results are highly unlikely to occur by chance, usually translated as an outcome that would be expected to occur no more than 5 out of 100 times if there were not a true difference in selection rates or scores. Employers need to monitor and record the effects of testing procedures on different protected class groups. The 4/5 rule should be applied to selection rates generated from applicant flow data to identify possible discriminatory effects. Tests with discriminatory effects should not be used unless strong evidence of test validity exists and less discriminatory alternatives are not available. It's important that potential disparate impact and the defensibility of tests be considered at the point when tests are being designed or purchased by an employer. A test can be successfully defended despite its discriminatory effects if the employer can show that the test is job-related and consistent with business necessity. An employer has legitimate interest in selecting people with the ability to perform jobs well. If more men than women are suited for some jobs or vice versa, discrepant test results might reflect the fact. It is incumbent on employers to have evidence of the validity of a test that is producing discriminatory effects. The validity of a measurement device or test refers to whether it actually measures what it purports to measure. Because employment tests are designed to help employers select people who will perform their jobs well, the validity of an employment test rests on how well it predicts future job performance. There are two primary ways to establish the validity of employment tests. The first is content validation. A test has content validity to the extent that it requires the performance of the same behaviors and skills as the job in question. A classic example of content-valid testing procedure is the use of a word processing or speed or accuracy test to assess candidates for a secretarial job. The test is clearly representative of behaviors and skills that are central to the job. A legal limitation on content validation is that it cannot be used to validate tests of intelligence, personality, or other intangible traits. However, Tests of job-specific knowledge or skills can be validated in this manner. Another problem is that tests assume that candidates already possess and can display the desired skills. In reality, many jobs can be learned relatively quickly. Testing procedures that screen out people who would be capable of performing the job following minimal amounts of on-the-job training and practice are not job-related and not consistent with business necessity. Employers should use content-valid tests as much as possible, but not to assess intangible characteristics such as intelligence and not for tasks that could be readily learned on the job. Employment tests sometimes go through many iterations and years of legal challenges before they meet content validity criteria. The second primary strategy for validating employment tests is criterion validation. Criterion refers to the measure of job performance. The essential component of criterion validation is demonstration of a statistical association between performance on a test and performance on the job. Criterion validation studies can either be predictive or concurrent. In a predictive study, the test is given to applicants and scored, but not used to make hiring decisions. Instead, the employer uses other information at its disposal. 6 months or a year later, when measures of job performance are available, these are compared to test results to determine whether people who scored higher on the test also tended to be better employees. Conducting a predictive study takes time because an adequate number of job candidates must be tested and hired, and a significant period of time must elapse before performance ratings are available. A concurrent study avoids these problems but has a less representative sample. In a concurrent study, the test that an employer wants to adopt is given to existing employees, a handy sample, and one not necessarily representative of job applicants. Performance measures for those employees are available or can be devised for the validation study. Evidence of validity again comes from showing a statistical association between test scores and job performance ratings. A typical measure of association is the correlation coefficient, the evidence needed to establish the validity and hence the job relatedness of a scored employment test comes from a validation study. Although the law does not strictly require that all tests be validated, it makes sense for employers to have evidence of the validity of all their selection procedures, but particularly scored ones. Rather than wait to be sued, employers should study the validity of tests before they're put into use and make sure that companies from which tests are purchased have done so as well. Second, although some tests may be appropriate for a broad range of jobs, evidence of validity usually applies to specific jobs or classes of jobs. An adequate validation study should proceed from a thorough job analysis in which the tasks of a job and the knowledge, skills, and abilities and other characteristics needed to perform the job are detailed. Employers should consider whether there are feasible alternatives to tests that have discriminatory effects, even if those tests are job-related. For tests to be used in selection decisions, they must be scored in some fashion, even if only pass-fail. Typically, cutoff scores are established for tests so that scores below the cutoff are deemed failing and disqualify candidates from further consideration. If the employer cares about the degree of the test for characteristic possessed, test takers with passing scores can be ranked and candidates with the highest scores can be chosen. One consideration in treating test scores is that employers must not adjust their scores of, use different cutoff scores for, or otherwise alter the results of employment-related tests on the basis of race, color, religion, sex, or national origin. This prohibition of what has been termed race norming, although not specific to race, means that employers cannot establish separate minimum standards based on protected class or obscure the existence of different standards by altering scores. Clearly, the results of a test are affected by what the employer determines to be a passing score. If a test is job-related, are there legal limitations on how high employers can set the bar in terms of cutoff scores? As a basic principle, the EEOC maintains that when cutoffs are used, they should be reasonable and consistent with normal expectations of acceptable proficiency. Some courts go further and require that if a test score creates disparate impact, cutoffs must be set so that they require no more of the tested for trait than the minimum needed to successfully perform the job. Requirements in excess of this level would be a business necessity. However, this does not mean that an employer must set a cutoff at a level at which an individual who scores below it would be able to perform the job. That is, an employer can set a cutoff at a level where there's much higher probability that persons who pass the test will also succeed in the job. However, requirements for one job must not be set unduly high based on the idea that persons hired will then be qualified to move on to other jobs. The banding of test scores can diminish the discriminatory effects of tests without unduly compromising the principle of selecting the most able candidates. In banding, test scores are treated as estimates of tested for characteristics. Because estimates contain errors from various sources, test scores are treated differently from one another only if the gap between them is sufficiently wide that the different scores are likely to reflect real differences in characteristics. Courts have upheld the practice of banding test scores, although the method used for banding should be established before the test is administered. The legal responsibility to accommodate disabled persons begins prior to their hiring and includes testing procedures. However, unless the need for accommodation is obvious, like a visually impaired person coming in with a guide dog, an employer is not responsible for providing accommodation unless requested to do so by a disabled job candidate. For this to be possible, candidates should be informed in advance about the types of employment tests used. An exception to the general rule prohibiting pre-employment inquiries regarding disability is that employers can require job candidates to document their need for accommodation in the application and testing process. Accommodation might include substituting written tests for oral tests, using large print test forms, allowing extra time for test completion, allowing breaks or rest periods during long tests, or substituting for testing requirements. Persons with disabilities that limit their vision, hearing, use of hands, concentration, or reading ability are particularly likely to need accommodation in testing.